hello, and welcome to the Difference Makers podcast live. Today, we have a very special guest in our seat. It is Paige Singleton. She's our director of medical malpractice, and she's been doing this for quite some time, and she's absolutely killing it in the industry. And so, we wanted to bring her on and just ask some questions. Can you guys hear me?
Yeah.
Sorry, guys, I'm hearing an echo real quick. Um, all right, I'm not hearing an echo anymore. All right, everyone.
Hello?
Here, I'm gonna try and take off these headphones. We'll try that. Okay. Hello, hello. Can everyone hear me? Someone leave a question in the comments, please. That would be very helpful. Anyways, so let's see. Sorry about these technical difficulties, guys. Can everybody hear me?
I can hear you, Anita.
You can hear me, Paige?
Yes.
Okay, awesome. All right, guys. Sorry about that. Okay. So anyways, without further ado, I want to hand it over to Paige. Can you go ahead and just give us a breakdown on who you are and how you got started in personal injury?
Of course. Thanks, Anita, for having me. My name is Paige Singleton, and I am the Director of Medical Malpractice here at Ramos Law. I have been practicing in personal injury and medical malpractice since 2015, so almost 10 years now. And I'm just here today to talk about medical malpractice law and to answer any questions that you have.
Awesome. So yeah, I just want to dive right into it. And if anyone has any questions, please be sure to just leave it in the comments. We are live on Facebook, LinkedIn, YouTube, and on Instagram. So if you are joining us, make sure to leave a comment and say hello. And if you have any questions that pop up, just leave them in the comments. But I just wanted to start off with the basics, Paige. What types of law do we practice here at Ramos Law?
Sure, absolutely. So many people know Ramos Law as a car crash law firm, but we actually practice in a wide variety of fields. We do take car crash cases, but in addition to that, we take a variety of personal injury cases such as slip and falls, trip and falls, any kind of premises liability. We also do medical malpractice. And we have a consumer protection division at our law firm, which is led by Matt Osborne, who is probably the best consumer protection lawyer in the state of Colorado. We also have an aviation department, and they handle a variety of type of aviation matters, including plane crash cases. And that's headed by Joe LaRusso. We also do vaccine injury cases where, someone's been injured by a vaccine. They're entitled to compensation. We do those types of cases. And I might be missing, workers' compensation. So if you've been injured on the job, Ramos Law handles those cases as well.
Yeah, we handle a large amount of cases, different, wide variety, but nonetheless, we are definitely helping people. And so that kind of brings me into the next question, how many offices do we have here in Colorado?
So in Colorado, we have 6 offices, and then we also have an office in Phoenix, Arizona, because we don't just handle cases out of Colorado. Firm-wide, we are licensed to practice in 22 states, and so we do have a pretty big presence in Arizona as well.
Nice. Yeah. A lot of people, I just want to let everyone know that just because we have our physical offices in Colorado and Arizona doesn't mean that we don't practice outside them. So the fact that we practice in 22 states is very essential to know. But other than that, I mean, let's just get straight into it. First of all, before we get there, I just wanted to say we have a comment from Jim. He says hello from LinkedIn.
Hi,
And
Jim.
we also have Rob said it's a top tier team. So thank you, Rob. We appreciate that. But without further ado, let's get into the meat of the conversation. Let's talk about medical malpractice. And what better to ask you than Paige, the expert on medical malpractice. So can you tell us a little bit about what it is?
Yeah, so medical malpractice is what we call a tort type of a claim. And a tort is basically when someone does something wrong that harms another in some way. And so a car crash case is a tort. Someone acts unreasonably on the road, causes a car crash, and injures someone else. So medical malpractice case is a type of tort wherein a medical provider, whether that be a doctor or a nurse, acts negligently and causes harm to a patient.
Wow. Okay, and so then can you tell me a little bit about what are some of the most common types of medical malpractice then?
Well, that's a tough question to answer because, medical malpractice can happen basically in any circumstance, any type of medicine, any practice area. But in terms of the types of cases that are usually taken to litigation, it's any kind of medical error that has a catastrophic consequence to the patient. And we'll talk about this a little bit more later. But generally, we don't take a medical malpractice case unless there is a pretty significant injury, because these are extremely expensive cases, and we don't want the client to have to spend more money than they can actually recover in court. So some of the types of cases that we see are, emergency room errors, such as failure to diagnose a serious medical condition. We see a lot of medication errors where the patient is given the wrong medication, and that results in catastrophic consequences. We see a lot of cases involving negligence during the labor and delivery of babies. We also see a lot of stroke cases where there's either a failure to timely diagnose or treat someone who has a stroke. So those are just some examples of the types of medical malpractice cases that we've handled.
Right. And so like when someone is in a situation, right, if there's maybe a misdiagnosis or they don't catch a stroke fast enough, how do people know if they have a medical malpractice case? How big does the situation need to be? I know you kind of listed off a few types of cases that we take that are most common, but how do people know when it's time to contact an attorney?
So the best advice that I can give you is that just call an attorney. If you've been in a situation where you've suffered an injury, during a medical procedure, it doesn't hurt to seek out counsel to see if you have a case. And so I encourage you to call our firm, and go through our intake process to see if you have a case. There are time limits on when you can bring medical malpractice cases, so it's important to contact an attorney as soon as possible if you think that you may have been a victim of medical malpractice.
So what's the statute of limitations for medical malpractice then?
Sure. So in Colorado, generally the statute of limitations is 2 years from the date that you knew or should have known of the injury and its cause. So it's not necessarily the date that the malpractice occurred, but it's when a reasonable person should have understood that they were injured and that could have been as a result of negligence.
Okay.
But there are other limitations that may apply to your case. For example, in Colorado, we have the Colorado Governmental Immunity Act. And so if you were treated by a government doctor or at a government hospital, the Colorado Governmental Immunity Act may apply. And under that act, you have to put the government entity on notice of a potential claim within 182 days, or about 6 months from when you knew of the injury and its cause.
Okay, that's interesting. So that actually leads me into a completely different question that I had later for you. But when it comes to these to the medical malpractice cases, are you suing hospitals or the healthcare facility or the actual staff?
That's a great question. So I'll start by saying in Colorado, we have a doctrine that's recognized in most states, and it's called the Corporate Practice of Medicine Doctrine. And under that doctrine, you cannot sue a corporation such as a hospital for the actions of a physician. Because the theory is that physicians exercise their own professional judgment, and that corporations don't practice medicine. They defer to the physicians. Now, in
Mhm.
practice, That's not the case, especially today, because corporations do have a lot of control over the practice of medicine. And I think it's a law that we should work to change in Colorado. But generally, if you are the victim of medical malpractice by a physician, you cannot sue the hospital for what's called, respondeat superior or vicarious liability for the act of that doctor. You can only sue the hospital if you can show that the hospital independently did something that was negligent, such as giving privileges and credentials to a physician who they knew or should have known could be a danger to patients, had many instances of misconduct or malpractice in the past. And so there's a claim called negligent credentialing, where you go after the hospital for bringing on a physician who was, a danger to patients, or who they knew, might commit malpractice due to the history of that physician. You can also sue a hospital or other healthcare corporation for the conduct of a non-physician healthcare employee, such as a nurse or a lab technician, anyone who's not a doctor. And so in that case, you can bring a claim against the hospital.
Gotcha. Okay, so that kind of helped break it up a little bit because I know that you had mentioned that before. And so when it comes to these medical malpractice cases, how much evidence do you need? What kind of evidence are you bringing to the table? So I know a lot of people have asked me this or asked us on social media about this. So if you can just go into that, that would be awesome.
Sure. And I mentioned earlier that these cases are really expensive. And that's because in Colorado, you're required to support a medical malpractice claim with expert testimony. And so we can talk about the elements of a medical malpractice claim. I think that was one of your questions for later on. But we have to show that the healthcare provider who we are suing was negligent. And in doing that, we have to show that they failed to act as a reasonable physician would have acted under the same or similar circumstances. And to prove that, we have to have an expert who's in the same or similar specialty testify that, a reasonable physician would have acted differently when presented with the same circumstances. And so we have to have experts to support that. And we also have to retain experts to show that the negligence of the physician was the cause of the injury that's being claimed in the lawsuit. And so, that's the most important piece of evidence, are the physicians who we are retaining as expert witnesses to come to court to testify in support of the claims. In the outset of the case, before we file anything, the evidence that we're relying on in our initial investigation are the medical records. And so we're looking at the notes of the physicians and the nurses to try to piece together what exactly happened during the care of this patient, and was the care reasonable?
Right. And so that brings me into another question. And we had some questions come in, so we will get to those. But real quick, when it comes to vetting these medical professionals and having them give their testimony, how do you vet, or how does Ramos Law vet those professionals?
That's a good question. So you're talking about if we're, looking for an expert to review a case of one of our clients, how do we vet those professionals?
Mhm.
So, first of all, it's really important that you get an expert who's in the right specialty. So if you have a case involving, a surgical error during a spine surgery, then you want to make sure that you have an expert who is board certified, either in orthopedic surgery or neurosurgery, depending on the specialty of the potential defendant physician. And you also, we kind of go through word of mouth. There are experts who I've worked with over the, nearly 10 years of practice that I know are trustworthy, or I'll talk to my colleagues about physicians that they've used. And we want to use someone who's going to give us an honest and unbiased opinion. I want to know, I don't want you to just support my case because you want to be paid. I want someone who I know is going to critically look at the records and tell me if there really was a breach of the standard of care by the physician, and if that meant something. Did it cause the injury? And so I want someone who I know is going to be a straight shooter and who's going to be credible when they take the stand.
That's good to know. And so I just want to go back real quick. We did have a question from Jim. Do you do information blocking cases also? Does that fall under medical malpractice or something else? I know it's possibly under the 21st Century Cures Act. So if you could just go into that.
Sure. So we do not, and at least in medical malpractice, we do not handle information blocking cases, at least not yet. It's something that I definitely want to learn more about, Jim, but we don't currently handle those cases.
Okay, good. And so let's see here. We have some other questions. And so I know we were talking about the evidence and how you guys piece together stories when it comes across your case, but what factors determine the value of a medical malpractice case? Because you also mentioned these cases are very expensive, right?
Yeah, absolutely. So when we're talking about medical malpractice, there are two categories of damages. There's economic damages, which are your medical expenses, past and future. If you've had to miss work because of the medical error, then you would be able to claim wage loss as well. And then when there are, catastrophic injuries, you might have other types of life care expenses, such as, needing someone to come to the house to help you with bathing and dressing and meal prep and helping with chores around the house, cleaning, cooking, all of that. So those are your economic damages. And then the second category is non-economic damages. And those are the more, intangible types of damages, like your pain, your suffering, your loss of enjoyment of life, impairment to your quality of life, impairment to your ability to walk. And those categories are capped. And in fact, actually in Colorado, there's what we call a soft cap on all damages. And so the soft cap is $1 million. So that means the most that you could ever get is $1 million, except it's a soft cap, which means that it can be exceeded for good cause shown. So the way that that works in practice is you take a case to trial in front of a jury of your peers. And let's say the jury awards $3 million. It would then be up to the judge to determine if there was good cause to exceed the $1 million cap and award the amount that the jury determined was, fair and reasonable for the injuries that you suffered as a result of the malpractice. But there's also a hard cap on the non-economic damages, the pain and suffering damages. And currently that cap is $300,000. So for any case that's filed through the end of this year, the most you can ever recover for your pain and suffering, your impairment, all of those damages is $300,000. We recently, the Colorado Trial Lawyers Association worked really hard to raise that cap for both, the cap and personal injury as well as the medical malpractice cap. And, they were able to get that cap raised from $300,000 to $1,575,000. However, that goes up in stages for the next 5 years. So starting January 1st, 2025, those cases that are filed after that date, the non-economic damages cap goes up to $450,000. And I'm sorry, I'm throwing a lot of numbers at you, but there was a big change in the law, and it's really important because it is going to make it so that we can take more cases than we were able to take before.
Right. And so, I know that non-economic damages has been a huge conversation in our office lately in the past few months, maybe. And so, why do these non-economic damage caps even exist? Why is there a cap on damages in Colorado?
So there's a cap because in the 1980s, there was a big thing called tort reform. And it wasn't just in Colorado. I mean, it was across the country. Basically, they were scaring the American public by saying, because we have so many medical malpractice lawsuits, the cost of healthcare is going up. And it's because of these lawsuits that, doctors are going to retire. They're not going to practice anymore. We're going to lose quality of healthcare, and it's going to get more expensive. And so there were huge efforts made legislatively in multiple states, including Colorado, to put caps on damages. And so in the 1980s, we enforced a cap. At the time, it was $250,000. And then in 2001, we raised it to $300,000, and it has been $300,000 for the past 25 years because the cap did not go up with inflation. And so it's not until this next year that we actually were able to raise the cap from $300,000. And actually, I misspoke earlier on what the new cap is. For wrongful death cases, in the event that you lose a family member to medical malpractice, that cap is going to go up to 1.575. But for non-economic damages for injury where there wasn't a death, that cap was raised to $875,000.
Wow.
So it's
And
still not
it's
high enough. I mean,
exactly.
we're really happy with the Colorado Trial Lawyers Association and the work that they've done to raise the caps, but we have more work to do because $875,000 is really not that much when you're dealing with a child who is permanently impaired and is going to need 24-hour care for the rest of their life. It's just not a lot of money to compensate that child for pain and suffering.
Exactly. And I know that recently you were a part of a team that had won a $19 million verdict. And so, how do these damage caps affect your verdict when it's something of that magnitude?
Well, fortunately, in that case, the caps don't affect our verdict. And that was in part because of the strategy that we employed. That was not a medical malpractice case, it was a personal injury case. So, in personal injury, there's actually a third category of damages that's uncapped, and that's called physical impairment. And so, we're able to get more money for our clients because we have that third uncapped category of physical impairment. And so in that case, we made the decision to not even claim non-economic damages, and we asked the jury to award everything that was, not economic in that physical impairment category. So the cap doesn't apply in that case.
And is this strategy, I know that this is different than a medical malpractice case, right? Because you said it's personal injury, but is your strategy is this used often in law or how does
It's
that?
So to my knowledge, I think I know of one other attorney who has tried completely just dropping the non-economic damages in a case. And so it's not used widely. I think it worked out really well for us in our case because we're able to have the entire judgment. We're not, we don't have to worry about a cap. And I think, for cases in which there's, a significant permanent injury, we are going to consider doing that going forward, of course, with the client's consent. It is kind of scary to drop an entire category of damages, but in some cases it makes sense because you don't want to lose a lot of the money that the jury has awarded. And the jury is not told about the cap on damages. So they don't know, you're not allowed to tell them. So they don't know that, when they're awarding $3 million for non-economic damages, that's going to be capped, and that the money that they think the plaintiff is going to get is actually not going to go to the plaintiff. The jury doesn't know that.
Exactly. And so we actually have a question that just came in from our very own Andy Keith. And he said, why would you not file all cases as BI cases? I'm not sure. I think, did you mean PI? He might have, I'm not sure, BI, but if we can just.
Sure. So Andy, if you bring a case against a healthcare provider, whether it be a hospital or a physician, it's governed by what's called the Healthcare Availability Act. And so there's really no way I'll just say in most cases, there's not a way to get around the medical malpractice cap. Now there are arguments for certain types of cases where you can say, hey, this is more of, an intentional act or, something that doesn't involve the practice of medicine, where you can argue that, you should have the PI caps instead of the med mal caps. But for the most part, when we're dealing with medical malpractice, it's going to involve the practice of medicine. And so we're limited to bringing a medical malpractice claim, and you can't get around the cap by calling it something else.
And so I actually wanted to go back to our question. I know that you mentioned that $19 million verdict was a personal injury case. And as a medical malpractice attorney, what was your role in that case?
Sure. So I handle both medical malpractice and personal injury cases because I just enjoy doing both. And in that case, it was actually to me, fairly straightforward, but the defense tried to make the medicine a little bit more complex than it needed to be. And so I ended up handling the injury portion of that case, and, directing and cross-examining the medical experts at trial. It
Wow,
was a
that's
case
awesome.
involving intracranial hemorrhage, so bleeding of the brain that our client suffered. And unfortunately, it led to him being a quadriplegic.
Wow. And I know that from the story, we have more videos on this. We actually have a whole YouTube video about this specific case and their strategy. And so if you guys want to go check that out, you can. It's in our YouTube channel. But you guys fought for your client so hard, and it shows with the verdict that you guys had received. So you guys really do justice with the clients that you have. But another question that I get a lot is, how long do these cases take? Um, do they vary between 5 years, or what does that kind of look like, the timeline?
Sure, that's a great question. So when we're speaking specifically about medical malpractice cases, generally these cases do not settle without litigation. So a lot of our car crash cases, we're able to resolve them without having to file a lawsuit. But with medical malpractice, it's very rare that you're going to have a recovery without actually going into litigation. We do have something that's fairly new in Colorado called the Colorado Candor Act. And what that is, when there's been an adverse medical outcome, a physician doesn't have to, but has, the option to send a letter to the patient and enact candor, which is basically a confidential meeting that a doctor can have with the patient to discuss everything related to that adverse medical event. And the reason that it was passed is because generally doctors and hospitals were not very forthcoming with patients when there had been a medical error because they were afraid of how that would be used in future litigation. And so with candor, they're able to have a candid conversation with the patient, and all of that is confidential and can't be used in litigation. And I'm sorry, this is a much longer answer than you
That's
probably
okay.
anticipated.
Oh,
But
that's okay.
with candor, it also allows the healthcare provider to settle with the patient confidentially so that that does not have to be reported to the medical board. Because when a physician or a nurse settles a medical malpractice case, that becomes public information. So you can go on the website of the Department of Regulatory Agencies and look up any medical provider to see how many malpractice claims they've settled. But under candor, they can settle without having to report that. And so because of candor, there are certain cases that we are able to resolve without litigation. And we definitely handle candor cases, and we have quite a few of them. But usually we're looking at litigation, and it takes us anywhere from 6 months to a year to get all the medical records, get all of the experts that are necessary to prove the case, and to file that case. And then once the case is filed, we usually get to trial within a year to a year and a half. So overall, the process takes around 3 years.
Wow. Okay. So is that pretty standard, compared to personal injury claims?
So, in terms of getting a case to trial, once it's filed, it's about the same. In Colorado, we have an order from the Chief Justice that they would like to have all cases set for trial within a year of the filing date. Not all judges stick to that, but that's similar to personal injury. But I think personal injury cases tend to resolve sooner than medical malpractice cases. So you have a lot that resolve just with the insurance company without even having to file a lawsuit. And then you also have cases that are filed, but they resolve fairly early on in litigation. At least in my experience with medical malpractice cases, if there is a settlement, it's going to be very close to the trial date. So we usually don't
Mhm.
have success settling these early on. It's not until we get very close to trial that we're able to resolve them.
Right. And so I know we're coming down to the end of our time here, but I did want to say if anyone else has any questions, please go ahead and put it in the comments. I have one more question for you personally. And I know that, we handle a wide variety of cases in general. I know your specialty here is medical malpractice, and you say you do personal injury here and there, but a lot of people ask us this question as well. They want to know, how often do we take on cases? Can you just go over that process and kind of get into that, please?
Sure. So for medical malpractice, unfortunately, we can't help many victims of medical malpractice because of how expensive the cases are, and because a lot of times there are bad medical outcomes when there wasn't negligence, where no one was at fault for that. It just happens in medicine where you have a bad outcome, but it wasn't anybody's fault.
Mhm.
And so we probably get about 450 medical malpractice intakes per month. And out of those, we might take one, one or two cases. So we take very few of the intakes that come in the door. And that's only because we need to make sure that there actually is a meritorious case, because we don't want to take a client and bring them through this litigation process and have them spend the money if there's not a reasonable chance that they're going to prevail in their claim. And it's also because we want to make sure that we're able to recover more than we're going to have to spend on that case. And so we're looking at both, is there a plausible claim of negligence against the healthcare provider? And also, what are your injuries? Because if you don't have a permanent injury, and we really can't recover a whole lot of money, then it doesn't make sense to spend hundreds of thousands of dollars to litigate a medical malpractice case.
Yeah, understandably so. Um, and so with that, I have no more questions for you. And I know we have hit about our 30-minute mark here. But I just wanted to thank you, Paige, for being here with us and answering these questions. You have a wealth of knowledge when it comes to medical malpractice, and it goes to show. So I just wanted to thank you for joining us today. And real quick, I just wanted to say thank you everyone who joined live. If you can please follow us on our social medias. And if you'd like to be notified of any podcasts or any live that we have going on, just make sure to follow our social medias. And other than that, we actually do have one more question here. If you want to read that off the screen there, Paige, can you see that?
So the question is from Susan, and it's, how do you go about determining if a case is meritorious? That's a really good question. So usually, what we'll do initially is we'll look at the medical records, and if we and what we're looking at is this, for example, like, is this something, let's say there's a surgical error. Someone goes in for an abdominal surgery, such as a hernia repair, and there's a perforation to the intestine during the surgery, which is not supposed to happen. However, perforation to the intestine is actually a known risk of the procedure, which means that it can happen even if the surgeon is careful and doesn't commit malpractice. And so we'll look at, okay, well, maybe this happened without negligence, but was there something else that the physician did, such as, failed to realize that there had been a perforation to the intestine for several hours or days, which resulted in, a severe infection and severe illness in the patient. And in that case, it might be a case. So we'll start by reviewing the medical records, but then we'll also defer to our expert witnesses who are in the same specialty as the doctor who may have committed malpractice to tell us, was there an error that was made by the physician? But in addition to that, we're also looking at if the mistake actually caused injury to the client, because you can have a doctor who negligently misdiagnoses a condition, but that didn't make a difference in the outcome. And in that case, you're not going to have a meritorious claim, because you have to show that the negligence is what actually caused the injury.
Wow. Wow. Well, thank you for answering that last question. But other than that, Paige, you've been an awesome guest here today, and I just wanted to thank you once again for joining us. I have no more questions for you right now, but I would like to encourage people again to follow us on social media, to stay updated on any more lives that we end up doing. And we also go ahead and post these on YouTube to replay if you would like to watch it again. So I just wanted to thank everyone, and thank you, Paige, for joining us. And other than that, I hope you guys have a good day.
All right. Thank you for having me.
Goodbye, guys.